This is The Language of Business with Greg Stoller.
We've all been passed over for promotions or laid off from jobs and then routinely complain to our confidants about it. Usually the response from your friends is, "You're right, it stinks, but life isn't fair and now you just have to move on." 95% of the time that's sage advice, but what happens when in your heart you feel something just isn't right at work and the company is doing something truly wrong or even breaking the law? Let's thicken the plot. Say you've tried to bring it to someone's attention or even report it, but all to no avail. Finally, you take a deep breath and get an attorney or the government involved as a whistleblower. Enter Chris Robertson. Chris's job isn't to protect the people reporting these events, but rather the accused companies. Chris, welcome.
Thank you.
So what is the official definition of a whistleblower?
Well, it's different depending on the context, but in general, a whistleblower is someone who, within a company, raises an issue about either unethical, illegal conduct or some criminal activity going on within a company.
And what does the whistleblower get out of it?
So the whistleblower gets two things out of it, depending on what they're reporting on. They could file a claim with the government and actually become a potential recipient of a bounty with certain programs. For example, the Internal Revenue Service, if you report tax problems, if they recover tax, you can get part of that. Now the S.E.C. with a new program under the Dodd-Frank legislation recently enacted just a few years ago, you can get a piece of whatever the S.E.C. recovers. And then under False Claims Act cases, which False Claims Act is any company that's submitting false claims for payment to the government, federal and now there's state law as well, they can get a piece of whatever's recovered from the company by the federal or state government.
And how much of the case that the whistleblower is pursuing is based on upholding the truth, or Riley looking at it, is it only about the money?
It depends. And what we always say when we go into a company, either before a whistleblower issue has arisen or after, is, quote, know your whistleblower. Is this someone who really believes in the company and is genuinely concerned that the company is engaged in activity that's going to hurt the company and therefore hurt them? Or is it someone who already sees that their tenure with the company is coming to an end and they're trying to figure out a way to game the system and maybe try to recover something on their way out?
So is it fair to say that whistleblowers come from varied backgrounds and there's no one-size-fits-all?
Very much so, and it depends on, for example, if it's an accounting issue. Company's been cooking its books, for lack of a better term, for months or years, or
even though this isn't a cooking show.
Exactly. That might only involve someone very senior, the CFO, the controller, someone high up in accounting. But on an issue, and your last guest mentioned Foreign Corrupt Practices Act, which is bribing a foreign official. Well, anyone in a company could know that a bribe's occurred. And so you could have someone at a very low level in the company reporting a bribe and potentially being a whistleblower and recovering under that. So a lot of it depends on what they're reporting on as to where in the company they might be.
And where do you folks come into the process?
We'll come into the process when the whistleblower has first raised an issue. And what we try to understand immediately is, have they already gone to the government or is it still internal? And if it's internal, then what we try and do is help the company navigate the investigation. Because ultimately what you want to do is you have to deal with the whistleblower, but you also want to investigate their claim and do it in a way that the end product you have is, quote, usable for purposes of going to the government or for purposes of defending yourself if there's a later claim.
So what you're saying is some of these could be worked out even without a suit being filed, that the whistleblower feels like he or she is getting just representation and you come to some agreement, but you don't necessarily have to get the government involved.
Or depending on the know your whistleblower, it may be that the whistleblower just wants it to be investigated and some disciplinary action taken internally as to that manager or as to that person. So oftentimes we get involved. The government's never involved, there's never litigation, and there's never a lawsuit. We just help the company navigate it so that the whistleblower's concerns are addressed, the company implements whatever discipline needs to be implemented and moves on.
Where do you then draw the line between a harassment claim versus a whistleblower claim?
So the way the law is structured in any of these whistleblower statutes is you can't retaliate. The word is retaliate. And retaliation,
from the company's perspective.
From the company's perspective. So first there has to be an adverse employment decision, either a demotion, a termination obviously of employment, or conditions for the employee that make it intolerable so that they feel like they can't remain at the company any longer. Those are really what has to happen. And then they have to connect that to their whistleblowing activity. They actually have to connect it somehow that a component of why they were treated the way they were was because they went and raised these issues.
Let's talk about training. What recommendations, steps do you provide for new entrepreneurs who are setting up a business for the first time to be wary of potential either harassment claims or whistleblower claims?
So the first thing any entrepreneur, any company owner should have is they should have a code of conduct. And they should have a policy in place for what will or won't be tolerated within the organization, and within that a means to report it. Now, if you're small, you don't have to have some big fancy whistleblower hotline, but you have to have somebody designated at the company that employees can take their concerns to, that they trust and they believe they can go to. The problem we see is the employee who doesn't feel empowered to go internally because they don't feel there's anyone they can talk to where they won't be harassed or mistreated. And so that's paramount. Even if you just have a handful of employees and you're just starting out, start having those policies and procedures early so that they just build on that, and there's always a place to go if you have a concern.
How about if you're an existing company that has already been in business for 2 or 3 years?
Then it gets more nuanced, it gets more sophisticated. Oftentimes you'll have a mechanism for it, but you may want to develop, as you get bigger, the capacity for someone to report something anonymously, and that's when you might hire an outside service to actually act as a whistleblower.
That would be the whistleblower hotline that you're referring to,
correct.
etc.
And all public companies, and we're talking entrepreneurs, so often not public, but all public companies have to have that. And so the question is just when is the right time to implement that? And as you prepare yourself to grow and hopefully become public and become the next Facebook or Apple or whatever, you want to start implementing these things so that you don't have to do them at the last minute.
Chris Robertson on protecting yourself and your company from whistleblower lawsuits. We've spoken with lawyers about how to set up companies for their clients or deal with legal matters once they're up and running. Now it's time to get the entrepreneur's perspective. And boy, do we have a good one. He was ranked as one of the 50 most important people shaping technology by Time magazine, and even began an advisory company bearing his own name. All coming up next on Language of Business.
We'll meet Julio Gomez next